Stephen Carroll in this Monday edition. We're going to continue our conversation about the passing of Ruth Bader Ginsburg, better known as RBG, Notorious RBG. Joining us on the First Midwest Bank hotline is my friend and a guy who knows his way around the courts. He's argued cases in front of the Wisconsin Supreme Court, Rick Esenberg, president of the Wisconsin Institute for Law and Liberty. Good morning, Rick.
Good morning, Stephen Carroll. How are you?
Good. How are you?
Great.
All right, so let's talk about it. You told me over the weekend that you had some history with Ruth Bader Ginsburg. Why don't you fill me in on that, and then we'll get to the legacy of Ruth Bader Ginsburg.
Well, you know, we often don't treat these people as real human beings, right? We get angry at them because we agree with them, or we turn them into something that's larger than life because we like what they do. My earliest memory of Ruth Bader Ginsburg was sitting on the steps at Lawson Hall, which is a building at the Harvard Law School, and there was a bunch of us there, and one of my classmates was her daughter, Jane, who I don't think would remember me. I don't think I'd remember her if it wasn't for her mother. We didn't know each other that well. But she was explaining, her parents' early struggle and, how they sort of made their way when both of them were, young law students, and her mother had to move to New York when her father got a job, and so she finished at Columbia. And so there are real human stories behind, these figures that sometimes we turn into abstractions. And I didn't agree with Ruth Bader Ginsburg on much of anything, but I think that she was, by all accounts, a very, very decent person who I think tried to conduct her job with a measure of civility, and she was good at what she did. She was a very, very good litigator, and while I think she got most things wrong as a Supreme Court justice, she was very capable at doing the things that lawyers do.
Give me an example of something you think she did wrong.
Well, I think that there has been a movement on the progressive left in which law is generally regarded as undetermined. And so the way that you decide a case is you decide what the outcome you want is, and then you reason towards that outcome. And so if you want the government, for example, Citizens United would be an example. I think that was clearly a correct decision because under the First Amendment, the government simply cannot limit political participation. But if you want the government to do that, if you think that by intervening in political participation, the government will somehow lead to better political outcomes, then I think you reason yourself away from the First Amendment. You find reasons not to follow it. And so I think generally speaking, Ruth Bader Ginsburg was a very adroit example of pretty standard variety left progressivism among lawyers and judges. She did it very well. I disagree with it.
And I said this a little earlier, that in 2016, she said that there was nothing in the Constitution that precluded an 11th hour nomination. What do you think about that? And address the hypocrisy of this whole situation, because it's frustrating for me.
Yeah, see, I think there is no hypocrisy because I think, first of all, I think you have to understand that from a legal perspective, she's absolutely right. The president has the absolute prerogative to nominate someone to fill this vacancy, and the Senate has the absolute prerogative to approve or not approve, to vote or not vote, to have hearings or not hearings. That's the law. Nor, I think, is there a norm that precludes the president and the Senate from doing this. There's a great article in National Review Online by a lawyer named Dan McLaughlin that dropped over the weekend, and he did some historical research. So there have been 29 occasions where a vacancy arose on the Supreme Court in an election year. The president nominated a replacement on all 29 occasions. So if Donald Trump nominates someone to replace Ruth Bader Ginsburg, he will be doing something that every president before him did in the same circumstance. Now, whether those nominees get approved or not tends to turn on whether there is an interbranch conflict. If the Senate is controlled by the president's party, then they normally get approved because the president and the Senate do not disagree on who should fill that vacancy. If, as was the case with Merrick Garland, the president and the Senate are controlled by different political parties and have a different view as to who should fill those vacancies, then they tend not to get filled. Then we tend to have to wait until there's an election so that the interbranch conflict gets resolved by the vote. So I don't think it's hypocritical because there is no governing norm or principle. Both the president and the Senate have the same obligation. That is, they have to decide who they think would be the best person to fill that vacancy. If they agree that the best person is, for example, Amy Barrett, then each of them have a duty to fill the nomination. The president has a duty to make the nomination. The Senate has a duty to confirm. But if they disagree, they also have a duty to maintain that disagreement. What happened with Merrick Garland is Merrick Garland didn't have the votes. A majority of the Senate did not feel he should be the person that fills that vacancy. And so they were not being hypocritical. They were not being overly partisan. They were not being political. They were doing their job.
Should they have given him a hearing, though?
Well,
Separate question.
We never used to have hearings. For many, many years, vacancies, including vacancies in the Supreme Court, would be filled without a hearing. That's a very recent phenomenon, really one that corresponds with the television age. But no, I mean, what would we know that we don't know now had there been a hearing? But the senators were perfectly aware of who Merrick Garland was. He was President Obama picked a sort of a moderately left justice who was 62 years old, who he thought that maybe the Republicans would confirm. The Republicans knew who he was, and they decided that they didn't think he was the right person to fill that vacancy, and so they didn't move forward. Now, you can disagree with them. You can say that, no, I think Merrick Garland should have been on the Supreme Court, but your disagreement is about substance. It's not about process, and it's not about hypocrisy. It's about coming to a different judgment regarding what should be done.
Rick Esenberg joining us on WTMJ. Take a break. After the break, I want to ask you, it's a serious question, but a general one. Should Supreme Court justices be celebrities? Rick Esenberg joining us. More with Rick after the break. Rick Esenberg joining us from the Wisconsin Institute for Law and Liberty, talking about the passing of Ruth Bader Ginsburg. Rick, before you joined us, I was talking about apparently the deathbed wish of Justice Ginsburg that said, "My most fervent wish is that I will not be replaced until a new president is installed." I don't like it. I don't want justices looking at their legacy beyond the time that they're alive. I don't want them weighing in on the politics of these things. She had a choice to retire when President Barack Obama was in the office. She chose not to. And to say something like that, according to her granddaughter, seems to me to be a mess. And then on top of that, I'm not sure that I want my justices, Supreme Court or otherwise, to be celebrities. I don't think it's good for the country.
Yeah. I mean, personally, I'm going to give her a pass because it was a human thing to say. But on your larger point, I agree with you. She doesn't own the seat. She doesn't have the ability to bequeath it to anyone. In terms of, the celebrity that, she had, becoming, the notorious RBG, there is a judge from Milwaukee who sits on the Seventh Circuit Court of Appeals, a guy named Mike Brennan, who was appointed by President Trump, recently confirmed. He said one of the wisest things that I've ever heard about the judicial role. He said that, what a judge needs to be about is self-abnegation. By that, he meant that a judge has to understand that it's not about him or her. It's about applying the law. And when you're a celebrity, when you think you have an audience, when you think you have people that you need to respond to, it becomes more difficult to do that. Now, I'm not saying that happened in the case of Ruth Bader Ginsburg because, I think she was a left progressive her entire career. As I said, I disagree fundamentally with a lot of what, that stands for, but, she did it very, very well. But it's very important for a judge to focus on the law. That's that's why we have this debate about Roe versus Wade and why, it's still such a controversial issue almost 50 years later. I mean, if you look at Roe, it's very difficult. You can be philosophically pro-choice, but it's very difficult to come up with a legal justification because it's very difficult to find a source for an abortion right outside of the preferences of a judge. And it's not in the Constitution. Privacy is not in the Constitution. And that's the key here. The judge has to be looking to, whether you agree with Roe or not, a judge has to be looking for some source of authority other than his or her personal preferences. And when you're a celebrity, it becomes more difficult to do that because your job becomes more about you and less about the law.
Okay, now the president has come out and said that the nominee, his nominee, when it's announced, will be a woman. Now, in your humble opinion, who do you think that he may pick, or who would you like to see picked?
Well, I'm from Milwaukee, so I would love to see him pick Dianne Sykes, who I think is a wonderful judge and would make an excellent Supreme Court justice, I'm sure, for a number of years. Now, the reality is that he may not do that because he's going to want to pick somebody younger. One of the people that's frequently named is Amy Barrett. Amy Barrett was a law professor at Notre Dame for a long time. She's a brilliant scholar. She's going to be controversial because, personally, her Catholic faith is very important to her. She's written some things which, I think people will argue about during the confirmation hearings. But I think there's no question that she is a highly qualified and brilliant lawyer. But there are other people he could pick. He could pick, Joan Larson. He could pick as a judge in the 11th Circuit, whose last name I'm not going to be able to pronounce correctly, Barbara Lagoa, I think, who I think also would be an excellent choice. So, he's going to have no shortage of highly qualified individuals to pick from. My personal favorite, Dianne Sykes, who is a wonderful judge, fully qualified. My guess is that it will be Amy Barrett or Judge Lagoa.
Rick Esenberg joining us on the AccuNet Mortgage Talk and Text Line, First Midwest Bank Hotline, I should say. The election is looming. We will have the president said he'll pick somebody by Friday. The hearings and the eventual confirmation, all of that will be determined. My question is, there are supposed to be 9 judges on the U.S. Supreme Court. If there are issues in this election, as we saw with Bush versus Gore, you don't want to have ties in the U.S. Supreme Court. That seems to be something that's critical to sorting out whatever election chaos we have. Am I wrong on that, or is there a genuine fear here that we could be stuck with a tie court on something as important as how the election plays out?
Sure. I mean, there's a long history of this. This is why courts generally have an odd number of justices. And, I've had this happen in a number of my matters. It's happened on some very, very important things here in Wisconsin, where the constitutionality of the school choice program, initially our court divided equally because one of the justices couldn't sit on the case, and it took a while before that all got sorted out. And so, I would hate to think, and I would hate to see the election being resolved by the United States Supreme Court. That is the last thing that we need right now. But reality is that it could happen. And, the reality is if the court sits 8, that there could be a split, which would really lead to some type of a crisis. I hope that doesn't happen, but it really is possible. And quite frankly, that's one more reason that maybe the vacancy does need to be filled so that we can have a fully functioning court going into what may be a very difficult period of time.
This is Carol's Pollyannish way of looking at life. I just hope when all is said and done that it's just cooler heads prevail and we just don't get, we don't ratchet up to be just so ridiculous. Like you said, we don't need that right now.
Right. And so I think that one of the things that, we should begin with is we should sit back and we should say, well, first of all, these people are justices. And, we talk a lot about, in the context of justices and judges, about, Democratic judges, Republican judges, liberal judges, conservative judges. And there is such a thing as a liberal or conservative judge. Ruth Bader Ginsburg was on the left. Antonin Scalia was on the right. There's no doubt about that. However, it's not the same as simply having somebody who votes the Republican way or votes the Democratic way or votes the left-wing way or votes the right-wing way every time, because judges have a discipline that they have to follow, right? They have to give reasons. Legislators and presidents don't have to give reasons, and the reasons ought to be persuasive, or, they're really sort of violating the precept of the profession. And so, I think we have to begin with the notion that this is very, 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 very important, but the future, it's not existential. The second thing we have to understand is that the norms on this are complicated. The president has always nominated somebody to fill such a vacancy, and the Senate has tended to fill the vacancy when the people have elected a Senate which is of the same party as the president, and that's what happened here. And so if this vacancy gets filled, it's not going to be some ahistoric thing or departure from the norm. It's going to be basically what has happened before in comparable situations. The Garland situation was not comparable.
He is Rick Esenberg, president of the Wisconsin Institute for Law and Liberty. Always appreciate your wisdom, Rick.
Yeah, thank you.